Judiciary Committee to meet, and it is exactly 1:30. We have a quorum, so Madam Secretary, let's establish the quorum.
Jackson?
Here.
Jackson here. Morlock? Morlock here. Anderson? Hertzberg? Leno? Here. Leno here. Monning? Here. Monning here. Wachowski?
Here.
Wachowski here.
Very good. A quorum is established. The first order of business is to identify the consent items and the other items so that if you're here for them, you will only be staying because this is so fascinating and not because you have any matters before us. So we have one item has been pulled at the author's request. That's item 13, AB 691 by Assemblymember Calderon. I believe that that bill is more likely to be heard next week. So item 13, AB 691, has been pulled at the author's request. We have two items on the proposed consent calendar. I believe they are still on the consent calendar. That's file item 6, SB 983 by Senator Morell, and file item 9, SB 1281 by Senator Block. Is there a motion on the consent calendar? Moved by Senator Leno. Madam Secretary, please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wachowski?
Aye.
Wachowski, aye.
5-0. We will hold the roll open for the absent members. We have a special order of business that we are doing this afternoon. We have four bills that relate to the mandatory arbitration system. We will take them in order, starting with Senator Wachowski's bill. That's file item 1, SB 1007. And we are, the basic rules in this committee are 2 witnesses in support who will provide 2 minutes of testimony each, followed by those who are in support, others in support, coming to the mic and giving us their name, their affiliation, and the fact that they support the bill. We then will bring the opposition in to each. They'll have 2 minutes each for 2 people. And again, those in opposition will be able to step up to the mic, give their name and affiliation and opposition, and then we will open it up for discussion. That's not a fixed in cement rule, but that's generally the way this committee operates. So we will start then with file item 1, and then when we're concluded with file item 4, we'll go back to the regular order of business, starting with file item 5. So with that, good afternoon, Senator Wachowski, and please proceed.
Thank you, Madam Chair. Senate Bill 1007 will affirm that a party has a right to a certified shorthand reporter in an arbitration hearing. Having a reporter's transcript can often be essential to a consumer obtaining justice when there are instances of misconduct, corruption, or fraud in an arbitration. When a party is denied a court reporter during proceedings, the lack of a record denies the party to the arbitration the documentation that would support claims of wrongdoing, whether on behalf of an arbitrator or parties involved. Senate Bill 1007 will codify the right of a party to an arbitration has access to a court reporter to transcribe any deposition, any proceeding or hearing to make that report the official record. Now, Senate Bill 1007 also provides for indigent consumers seeking a court reporter will have one provided to them at the expense of the non-consumer party. A low-income consumer should not be deprived of having a transcript of an arbitration, nor be unduly financially burdened because she can't afford one. I am committed to amending the bill based on the committee report on removing provisions about vacating an award if a party is denied this right, and amending the bill so that the consumer may seek a court order to compel the arbitrator to grant her requests. Establishing a party's right to a court reporter will help ensure a fair and unbiased arbitration process and give consumers a fighting chance to defend themselves when the arbitration is unjust. And with me today is Mr. Doyle with the Conference of California Bar Associations.
Thank you. So that I'm clear, Senator Wachowski, you are prepared to take the suggested amendments discussed on page 6, item 3?
Yes, yes. On the second part about the author may wish to further amend to ensure that the right of to request a court reporter shall be made at the onset of the arbitration. I want to be careful on that because I don't want to have it one and out. I don't want to have the consumer that didn't know at the beginning of a deposition that they would not be able to request a court reporter at the end of the proceeding if it's segmented, right? Because sometimes these arbitrations are big cases. On the other hand, I don't want to have the credit card company or the other non-consumer party saying everybody arrives to do the deposition and they say, oh, I want a court reporter, and then the place falls apart. So I'm working with the advocates to make sure we get that right balance so that we don't unduly bind the consumer.
One of the concerns that I know we discussed and that I would like you to continue working on if this bill should pass through the committee is the notion that the request for a court reporter should be made within a reasonable time in advance of the proceeding for which it is sought. And the reason for that is frequently it takes quite a bit of time to set a date when everybody can get together for the hearing. And part of the delay tactics that are frequently used, in my experience, in the litigation process is to come in at the last moment and make a request for something, which then, in this case, would require the opportunity to present a request to the court. You then have to set that matter for a hearing, and then come back and come to a mutually agreeable date, yet again, for the hearing. This could delay these proceedings for months and potentially even years. I'd like to the extent that it's humanly possible to avoid that, to make sure that when a request is made for a court reporter, it is done so that it does not disrupt the calendaring for a proceeding, which then results in months and months and months of additional delay, either because the arbitrator isn't available, counsel for one party isn't available, the parties aren't available. I mean, we've all seen this happen. We need to do everything we can to protect from that happening, whether it's being used as a sword or a shield by either party.
Right, and I agree with you on that. I just, when I look at these different phases of the arbitration, whether it's the preliminary hearing or information in exchange or hearings or post-hearing submissions, you wouldn't want to say that you're at the hearing and you request early and they say, oh no, when the filing and the initiation occurred, you didn't do it in time. So that's what I'm concerned with.
So will you work with us on language that will address your concern? I think it's a similar concern, but again, we don't want these things to go on forever. And that's part of at least the advertised benefits to arbitration is that you have a date certain. We don't want to see that being undermined by this request.
That is an advertised benefit of arbitration. I agree. We'll work with staff and our advocates to make sure we get the right language.
Very good. Thank you. Thank you. And with that, did you wish to say anything further, or are we passing? To the witnesses.
Witness.
Okay, very good. Good afternoon. Please identify yourself.
On behalf of the Conference of California Bar Associations, and as I was saying, between your discussion with Senator Wachowski, you've covered pretty much all the bases here. I think that it's an important bill. It's important that we be able to have a record in arbitration proceedings because, like other judicial and quasi-judicial proceedings, the existence of a record is key. We think it's important that people, in terms of working with the staff, I think that it's important that we try to provide that the participants understand that this right exists, and that the fact that it needs to be exercised early in the process or as early in each aspect of the proceeding, and try to minimize delay, but while making sure that there is no reason for an arbitrator to unreasonably deny the right to the reporter, which could prove to be crucial later on. So I frankly think that the staff's effort here is going to produce a much better bill, and we thank you very much.
Thank you. Other witnesses in support? All right, none. Any witnesses who'd like to just simply step forward, give their name, identification? Very well. Witnesses in opposition? Excuse me, sir, did you wish to come up and speak in support of the bill? No, in opposition. Well, now is the time for the opposition to come forward. We have 2 witnesses in opposition who may speak for 2 minutes each. Good afternoon.
Good afternoon, Madam Chair. Chris McKaylee on behalf of the Civil Justice Association of California. First, I wanted to thank you, since I didn't have an opportunity to testify at your March 1 hearing. I thought that was very helpful to set the stage, so we appreciate that. We did file a letter of opposition. Your analysis on page 6 outlines our stated concerns, and as your committee staff has indicated, our concerns related to including this among the standards for a vacating of an arbitration award. In light of the senator's indication that he was going to remove it from there, that might resolve our opposition in toto, but of course, we'd have to wait and see what that language looks like. So hope to continue to work with the author and your staff in that regard.
May I just inquire, Senator Wachowski, did you indicate that you were going to remove the vacature?
Yes,
Okay,
yes, that was it.
so that should.
It was the second portion about the timeliness is where I'm having.
All right, so we'll continue to get the parties together so that that resolves your concerns if possible.
Very good. Thank you, Madam Chair.
Very good. Other opposition. Good afternoon, sir.
My name is John Warnwell. Good afternoon. I'm an arbitrator and litigator and have for 40 plus years, formerly a chair of the State Bar ADR Committee. I'm on the board of directors for CDRC. And I had a couple comments. I think the change that's been proposed is good, but you need to realize that if you're going to have an appeal to the court where there's been a request for a court reporter denied, you're having the court then review an interim order of the arbitrator. And the law, which is quite strong in California, is that the courts generally see this case when they rule on a motion to compel arbitration, and then when they see a petition to confirm or vacate award. And there's been a very strong policy about not reviewing interim rulings by the court. So if you want to pursue that path, you have to realize that you're going to be then having the arbitration interrupted to appeal interim to the court. The other thing I wanted to say was, with indigent consumers, currently, if you were to qualify for a fee waiver in court, you're not entitled to have the court pay for your deposition transcripts. So you're actually giving the indigent consumer greater rights than they would have if they were in court with a fee waiver. Now, let me just say from my experience, and I've done probably 1,500 arbitrations in my career, is that American Arbitration Association, in its rules, and I can't speak to other providers, specifically has a rule about the right to have a court reporter for any of the arbitration provisions. And usually we address that when we have a pre-hearing conference. We say, who wants to have a court reporter? And generally speaking, nobody does. But you always leave open the opportunity to say, well, at least, a couple weeks before the arbitration, if you change your mind and you want to have a court reporter, let the parties know. And in my experience, it has never been denied. Now, also let me say that unless you have an arbitration, substantial damages, in most of the consumer arbitrations that I do, there is never a court reporter. The parties don't ask for it. And so I'm just saying that I read the analysis this morning, and I was talking about having these arbitrations reported, but I just want to say it's infrequently done. The only times that I've done it are when you have big arbitrations, 3-arbitrator panel, multi-million dollars that are involved, and there often the parties will get dailies so they can review at night and answer questions of the arbitrators and get a sense of where it's going. But in most consumer arbitrations, particularly the expedited ones that are less than $75,000, you just don't have court reporters. Thank you.
Thank you very much. Appreciate your insights, and congratulations on surviving 1,500 arbitrations in your career. That's quite a feat. Any other witnesses in opposition? Seeing none, we'll bring it back to the committee. I think part of the concern that I was discussing with you is if there is an opportunity, for example, a pre-hearing conference, it would seem to me that's the place where the request should be made. I think that the witnesses' observations were very helpful. I assume, too, that we won't be seeing a lot of these, but the fact is that one of the things that we observed during that March hearing is the fact that there are really not a whole lot of rules in arbitrations per se, and that the extent to which there can be some accountability or some record of these proceedings which are not in public, which are not necessarily requiring any of the rules of evidence, and what have you, and frequently, frankly, don't even require the judge to follow the law. This is a safeguard, and I assume that's the reason that you presented this bill to us today.
Yes, the suggestion that we're giving greater rights to people in arbitration when, as the chair notes, that the rules of procedure and evidence and law don't even have to apply. It's a little step for consumers, and just keep everybody honest with a record, and I would respectfully urge an aye vote. We have a motion.
All right, are there any other questions from anyone? A motion by Senator Monning. Okay, we're all set. We'll go ahead and then call the roll, please.
The motion
is
due pass as amended to the Senate floor. Jackson?
aye.
Jackson, aye. Morlock? Anderson? No. Anderson, no. Hertzberg? Aye. Hertzberg, aye. Leno? Aye. Leno, aye. Monning?
Aye.
Monning, aye. Wachowski? Aye. Wachowski, aye.
That vote count is 5-1, and the bill is out. All members having been present. We'll move on now to file item 2, which is Senator Monning. This is SB 1065. Good afternoon, Senator. Good afternoon, Senator Monning.
Thank you, Madam Chair and members. It's my pleasure to present SB 1065, and I'm just going to preface this. We're talking about a very technical, limited universe of people. You'll hear from some witnesses today that will underscore the absolute importance of this through the lens of preventing elder abuse and providing remedies to victims of elder abuse. SB 1065 will help victims of elder abuse who are old and dying and who need a speedy resolution of the elder abuse case. SB 1065 applies in this situation only. There's a senior who's been abused and files an action under California's elder abuse law, existing law. The victim seeks and receives a trial preference under existing California law because she is sick and dying and over the age of 70. The defendant, usually a nursing home, files a motion to compel arbitration, alleging the case should be decided by forced private arbitration and not the court. Further condition under this legislation, a judge finds that the defendant's arbitration provision was unconscionable and therefore invalid, found by the court. Under current law, after all those conditions have been met, the defendant whose arbitration provision was found illegal by a judge, the defendant can file an appeal, but a defendant only files the appeal for the purpose of delaying the case since the appeal takes 1 to 3 years. At this point, the victim should be able to proceed to the speedy hearing that was originally ordered by the court, but under current law, they cannot. SB 1065 fixes this defect, fixes this injustice by eliminating the automatic right to appeal after a judge has found the contract to be illegal. It is routine in elder abuse cases for a defendant who wants to avoid a jury trial to file a motion to enforce arbitration based on an arbitration agreement, which they drafted, and then coerce the victim into signing. Members, I'm going to ask for an aye vote to help protect seniors' legal rights in elder abuse cases. First, I'd like, through the chair, to present 2 witnesses in support. The first would be Pam Lighton, whose father went through this experience. She'll be followed by Catherine Stebner on behalf of the Consumer Attorneys of California.
Very good.
Thank you.
Thank you very much, and welcome. 2 minutes each, if you would.
Good afternoon. I'm Pam Lighton from Modesto, California, and I'm here to share my father's story. George Rowland was my father. He worked his whole life and raised 7 children. He was a great provider. He was a good person and a very loving man. At the end of his life, he was abused, first in the nursing home and then by the legal system. My dad had successful knee replacement surgery and needed rehabilitation in a local nursing home. What should have been a short period of rehabilitation became a horrible nightmare that nearly killed him. After only 11 days in the nursing home, he developed bone-deep bed sores on his leg and his bottom. He became septic and had to be hospitalized for a month. The doctors told us to prepare for a funeral. His doctors told us that due to the bed sores, his leg should be amputated, but we begged them to let us take him home. Through the grace of God and a wonderful private caregiver that we paid for out of our pocket, my father's bed sores were healed. He was crippled from his joints from being permanently locked in place and needed 24/7 care. What happened to my dad was elder abuse. The facility was later cited by the state for understaffing and neglect. At the time my father was admitted to the nursing home, I signed the admission agreement. The agreement contained 2 arbitration clauses, which I crossed out because I didn't agree with them. Faced with mounting medical expenses for my father and knowing what happened to him was horribly wrong, we filed an elder abuse action against the nursing home company. Because of Dad's age and poor health, he was granted trial preference. The unsigned, crossed-out arbitration clauses never came up until just a few days before our trial date, when the nursing home company filed a petition to compel arbitration. This was their way to delay the case and prevent my father from getting a trial while he was still alive. The trial judge denied the petition since there was no valid arbitration agreement, but the nursing home company immediately appealed. This one act stopped my father's case from being resolved for 2 years. Current law allows the nursing home to do this, even if the arbitration agreement is blatantly invalid and non-existent, as it was in my dad's case. Unless and until SB 1065 is made into law, people who abuse elders can delay justice in the hopes that the victims will die while the case is on appeal and cap the damages the abuser may have to pay. Ultimately, and through God's grace, we won the appeal, but it took 2 years to get the case back to trial. While the appeal was pending, we were left in limbo, struggling to make ends meet and provide the care my father needed. We did not have the money to pay for the many things that could have benefited him, such as therapy and equipment. After the appeal was over, the case was reset for trial. Just a few days before the trial was to begin, the defendant settled. Unfortunately, this delayed justice was too late for my father, and he died shortly thereafter. He was never able to benefit from the money paid by the defendant. The people of California need SB 1065 to stop this from happening to other elder abuse victims and their families. Look into your hearts and please do the right thing. Please vote aye.
Thank you very much. Sorry about that situation. It doesn't speak well for the legal system. And these are the kinds of abuses that we see all the time, people who game the system. And delays like that, I think, I remember talking to a friend of mine who worked for a big firm who said their motto was, justice delayed is justice. And we have to try to address those problems. So thank you so much for your testimony. Next witness, good afternoon.
Senator Jackson, and a special hello to my senator and neighbor, Senator Leno, for many years. My name's Catherine Stebner, and I'm here on behalf of the Consumer Attorneys of California, and I am the principal at Stebner & Associates in San Francisco. I've been representing families and elders against skilled nursing facilities and residential care facilities for the elderly, which are assisted living and elder abuse cases since 1987, almost 30 years. California has a strong public policy in protecting its elders, and that's why it's embodied in the Elder Independent Neglect Act. In addition, Civil Code Section 36 allows a senior who's over 70 and is in poor health to receive a trial preference, which is in 120 days after the hearing. And these are not lightly given in our courts. The judges don't just grant them. Under current law, a nursing home or assisted living facility can file a motion to compel, as the first witness talked about. And if they lose the motion, even if, for example, if it's crossed out, which takes a lot of chutzpah to do that, actually, and you don't hear that very often, they have the unilateral right for direct appeal. Be clear that if it would have been the other way around, this witness would not have had the same right as the nursing home. It's only the other way around. So the current law allows the lawyers to basically hold this up and wait for the elder to die. And I actually, in my years of practice, have heard defense attorneys say that to my face, that that's what they're doing. And so this is a practice that happens. I represented a woman, Marilyn, who is a beautiful, elegant woman who was raped in a nursing home at age 88. She contracted herpes. She was married to the same man for 68 years. It was her childhood sweetheart. The facility filed a motion to compel the arbitration clause because her daughter, like the first witness, had signed it, and it was invalid. We won the motion, saying that it was invalid for different reasons, and we also won the motion to be heard within 120 days. But again, like the first witness, they appealed that ruling. So basically what we have here are two competing areas, two different thoughts. We have California saying, and in fact in the elder abuse statute saying, we want you to bring these cases because people were not bringing cases against elder abuse because they don't have wage loss, they're older, and before this act, no one was bringing these cases. There was about 3 of us in the state of California even bringing them. And so we have that, and then we've also got the law that says, if you're over 70 and you're dying, you should have a quick trial. But then we have this competing law that comes and butts right up against this. And so in my case, we waited. We won after 1.5 years in our case. My client said she was going to stick around. She did. Unfortunately, her husband, who was our main witness of 68 years being married, died during the appeal. So it's a Hobson's choice. You basically have to choose to go to arbitration or on something that you literally crossed out, which you shouldn't have to do because you didn't contract for it or it's unconscionable, or you have to possibly die on appeal. So we applaud you for bringing this bill, and thank you.
Thank you. The story is so compelling. I apologize I did not stay with my 2-minute rule. But clearly, this is the kind of thing I think that we are anxious to address here, certainly today with this legislation. Any other witnesses in support? Please come forward. Just state your name, affiliation, if you would.
Good afternoon. Aaron Lewis for the Consumer Federation in California, and strong support.
Thank you.
Mike Montgomery, Congress of California Seniors. We co-sponsor the bill. This is a classic example of the justice delayed is justice denied. Vote aye, please.
Thank you.
Ignacio Hernandez on behalf of the California Continuing Care Residents Association in support.
Thank you.
Hi, I'm Sandra Drain, Pam's sister, and I'm in support of SB 1065.
Thank you
Please
so
vote
much.
aye.
My name is Charlene Young. I'm the